recording parent meetings and conferences as well as ARD or 504 meetings in Texas. Can we record even if asked and the ARD told that we don't have permission? Now, in Texas, guys, it's called an ARD, but it's an IEP meeting is really what it's. Anywhere else, it's an IEP meeting. But, Texas is Texas. So can the school stop a meeting if we say, yes, we are recording, and the school says that you can't? This is getting out of hand, and I agree. But at the same time, I can tell you with regards to the recording standard, number one, you have to look at what kind of state you live in. Are you in a one-party recording state or a two-party recording state? In a one-party recording state, it's a little bit easier to answer the question. And that is, as long as you're aware that you're recording, you don't have to tell them that you're recording. Okay? All right. Now, they could ask you, and I wouldn't necessarily recommend lying, because at that point, they're not giving their consent. It's sort of like, in a one-party recording state, what they don't know isn't going to necessarily hurt them. So it's if they come out and say, is anybody recording, and you are not honest about it, as long as you're not later divulging that you're recording. I don't know. Some parents, I'm not saying from a lawyer perspective, I'm just saying some parents just sort of don't say anything, but it's only for their benefit. Could you introduce it in court? No, you wouldn't, because they said on the other side, are you recording? And you answered with a lie. So at that point, you just sort of destroyed your evidence. Now, if they don't say anything and you're able to go through your meeting in a one-party recording state to where only you need to give the consent, then at that point, yes, it could be introduced not as direct evidence, but as supporting evidence to whatever's being said by somebody else. Like rebuttal evidence. And we've used it that way in prior hearings of ours, not as substantive evidence, but as supporting evidence when questioning, let's say, the special ed director as to what went down in X, Y, and Z meeting. And she decided that she wanted to lie about it. Now we have the transcripts from that meeting, and this is what you said. Okay. And at that point, yes, this rebuttal evidence, we were able to introduce it. One party recording state, though, in Alabama. Okay. So if you're in a two-party, that means both parties have to consent to the recording, not just one party. So in that regard, you're up against that wall. And many schools are starting to say absolutely no recording because they don't want to be held accountable. Okay. That's the only reason that you wouldn't want to be recorded in an official meeting. Now, I'm not a fan of sitting around being recorded all the time. Okay, I'm not. But this is an official process where there's parity on the team. Okay, I'm not going to say there's equality, but there's parity on the team to where the goal is consensus. Everybody agrees. And the reason parents want to record is because there's a lot of crap and lies that are said in the meeting that then don't find themselves onto the IEP itself. And especially if the school system is one of those that has a penchant to send the parent the IEP later. Tell you what, we got everything, we captured it in notes, and then we're going to go work on the wording. And that's where the language gets screwed up. Okay? Language is important. Written language is very important, especially in the law, because it tells us what the intent is. Okay. And that's where the problem is. And that's why parents want to be safeguarded with the recordings. So what do? Well, if you're in a two-party recording state, there's not much you can do. Now, what you can do, because when you look at the feds and OSEP, what is it said about recording? They leave it up to the states and they leave it up to the individual schools in large part. At the same time, it becomes a violation of your parental rights in advocating for your child if there's a legitimate reason why you need the recording. Okay. And that's where you can make that argument. Do you have a disability yourself? For example, I have dyslexia, or I have, auditory issue. Let's say English as a second language. And I need these recordings in order for me to go back and review in order for me to understand. That is where within the law, it warns the schools that yes, there's some latitude that you guys are given. We're not going to tell you can or that the parent can record meetings outright. But what it says is that you can create your own policies in this regard. You just can't discriminate, because if the parent can show a reason for why they need that recording in order for them to fulfill their right to full parental participation in this process, then you need to acquiesce and you need to be permissive of that. Okay, either you need to record or you need to let them record. But you would need to submit that in writing. You'd need to sit there and explain the compelling reason. And in some regard, you might need to even provide supporting documentation to support the justifications. Okay, I'm not saying all the time, but I'm just saying that if you have compelling reasons, then yes, they should follow law in that regard. And well, I'm not going to say the law, the guidance in that regard, because what they don't want to do is potentially tip this over to where by denying you your recording ability, that they're denying you your right to full parental participation for a very valid, justified, let's say medical or diagnostic reason of why you record or why you require it. Okay. Now, what hasn't been challenged yet, a parent saying the hell with it, and then having that be a component of a federal court case to where it's ruled on those merits. I haven't seen a case like that. Now, it doesn't mean that one doesn't exist out there. It just means that I haven't seen it. Maybe I'm late to the game. Where I'm talking about on a federal court level, the courts have considered the issue as to whether the recording itself serves in a purpose of full parental participation. Okay, but as of right now, the guidance is exactly what I explained. If you can show a compelling reason why you require the recording in order for you to fully participate, then yes, it needs to be allowed. And you're probably going to have to argue with the school about that. But you need to make a compelling argument, and it needs to be in writing. Okay, and it might take you a little bit of time to get that approved. Okay, but that's the only answer I can give you, especially if you're in a two-party recording state.